Well, good afternoon, everybody, and welcome. I think we'll get going. I'm Catherine Kennedy. I'm a partner here at Mills & Reeve, and my colleague Stephanie Hawthorne is here. We're going to talk today for the next, say, 30 minutes, 40 minutes, something like that, about the key legal principles that maybe impact unmarried couples. So you can have a few pointers along the way, hopefully, about the legal implications of living together, what happens when you separate, and in particular looking at property ownership, responsibilities financially for the children, and some asset protection issues. Okay, so cohabiting couples or unmarried couples, whether same-sex or opposite sex, are the fastest growing type of family in the UK at the moment. But as family lawyers, what we recognise and deal with, on a sort of daily basis, is that the law surrounding relationship breakdown when you're not in a marriage is actually far, far more complicated than in a marriage. And we're relying on trust law, property law, laws that really are designed for business purposes and perhaps business transactions rather than for relationship breakdown. And there's over 3 million cohabiting couples now, so that's about double what it was 20 years ago. So this area, is an area that we probably do need to think about in terms of specific laws for protecting people. Mills & Reeve conducted a survey a few years ago now because we were concerned about this area, and the public didn't really understand their rights or their responsibilities on this issue, and it confirms some of these statistics. 25% of people think or thought unmarried couples living together for maybe more than a year had automatically the same property rights as married couples if they were to separate. And remember, on divorce, if you separate, the starting point, for example, in relation to the family home, is that you own that equally, 50-50. 35% didn't know, for example, that beneficial joint tenants, if you own a property as joint tenants, means that you own it 50-50, as opposed to tenants in common, where you can specify the shares you own the property in. And 60% didn't know that if you own it as beneficial joint tenants, the property will pass automatically to the other party on death. And 75% didn't know that any financial claims could be made upon separation for any children of the relationship. So there is a lot of misunderstanding, a lot of misinformation, lack of knowledge, and debate is raging amongst us as lawyers at the moment as to whether we need to focus on educating people, which today is all about to some extent, or legislating for people in different situations. So it's all about myth busting, I'll put it that way. And I guess if you remember only one thing from what we say today, it's please remember that it doesn't matter if the relationship lasts 1 or 20 years. There's simply no such thing in this jurisdiction as a common law marriage. It doesn't exist. I understand why people think it might. I think pre-1700, pre-Marriage Act, you could jump over a broomstick and you were recognised as a common law spouse, but it's simply not the case anymore. Look how many years it takes to sort of brush away those sorts of myths. It just doesn't matter. You can have a strong case for ownership of a property sometimes after a year. It could be after 25 years. It's nothing to do with the length of time of the relationship. So I thought it might be helpful just to have a look at a quick case. Thinking about, I hope that you can still hear me. We've gone still. There we are, fine. So this case study, and it applies to same-sex relationships as well. It's a cohabiting couple, Julie and Paul. They have a 3-year-old son together, George. And Julie's daughter from a previous relationship, Laura, who's 9, also lives with them. She lives with Julie and Paul. Now, Paul owned the house. He owned it before he met Julie. She moved in with her child, with Laura, and then Paul and Julie had George together. And in order to accommodate the whole family in this scenario, Paul paid for an extension to the property. Julie helped with things. She helped choose the furniture, but the mortgage, the utilities, the extension, all those sorts of things, they were all paid for by Paul. Then, several years later, the relationship breaks down. So we then look at what financial claims that Julie may have in relation to the property or at all. They're not married. So unlike a spouse, if you were to separate married, there could be claims for spousal maintenance if there was a huge disparity in income, for example. We're reliant in a scenario like this on the complexities of trust and estoppel laws, which can be very complicated, can be very expensive, and can, in some people's views, lead to perceived injustice. So, is there any evidence that Julie owns a share of the property? Firstly, we need to look at the title deeds, so you'd look there. And assuming the title deeds are, as we expect, in Paul's sole name, the onus is then on Julie to prove to the contrary. And she has three ways of doing this in property law. Number one is the resulting trust. So you buy a house, let's say, for example, for 400,000. It's owned legally in one person's sole name, but the other person, say, put £100,000 deposit down towards that sort of, say, 400,000 pound price. The resulting trust would say their interest in the property results as a consequence of their financial contribution. The second area in which you may be able to establish a claim is a constructive trust. And this is where you would need to prove that there has been a common intention, which can be expressly written down or said to one another, words said. So you imagine the evidence on that, who said what when. It's very, very difficult stuff. Or it can even be inferred from behaviour, from the dealings between two parties. So once you've established common intention, you then have to establish reliance on that intention to your detriment. So, for example, I relied on what she promised to me in terms of the house. I wouldn't have done all that work and spent all that money on renovations or whatever it might be, but for those promises made to me. So you have to prove common intention and detrimental reliance. And the third area in which you can look at in terms of property ownership is proprietary estoppel. A promise made or an assurance given that a reasonable person would have understood in those circumstances to be exactly that, then reliance on it and detriment suffered. And we often find in disputes between cohabiting couples when they separate, when we're talking about a property, that you actually look at all three legs there, all three different sorts of claims. And you almost say it could be a resulting trust and or constructive trust and or proprietary estoppel. You almost plead all of them. But obviously that requires a huge amount of preparation in advance, huge amount of evidence gathering in advance. It can be really risky litigation. So on the facts here, Julie hasn't made any financial contribution to the deposit. She's not made any mortgage payments. She's not paid any building costs of the extension. And we don't think Paul's made any promises to her. And so absent any written evidence to the contrary, there's no declaration of trust, no written agreement between them, no common intention, no detrimental reliance, she's going to find it, well, impossible. I was going to say difficult, but impossible really, to suggest she has an interest in that property. So bear that in mind if you're, depending on the circumstance, if you're trying to protect your interest or if you think actually you should be protecting a contribution to a property, a financial contribution. So if Julie could show she has an interest in the property, how do you then look at quantifying her share? Again, we would be looking at the evidence. What evidence is there as to the amount she should get out of this property? What's been agreed? And again, if there's something in writing, it's much easier to evidence. The cases which are very, very difficult are where you have nothing but promises potentially made, really, really risky litigation. So what was put in writing, what was said, what was agreed, what was contributed, which you can evidence, bank statements, etc. What was financially contributed, the resulting trusts. And even if there is no evidence, I'm sorry, I think I might be breaking up occasionally, so I take a pause, and when I can see myself moving, I'll carry on. Even if there's no evidence, and it's just conversations, just oral conversations between people, we do have to be careful because courts can impute intention. So it's not an implied intention, it's imputed by third parties. And you actually can end up in a situation where a court reaches an outcome that actually neither of you intended. Okay, so if we just go back to basics and the two different layers of ownership, so that you understand that when you buy a property, what's on the title deeds is the legal ownership, and that could be as joint owners. And underneath that, resting underneath that, is the equitable ownership, the beneficial ownership. And often what we're talking about in these situations is we know what the legal ownership is, that's set out in the deeds. But the discussions and agreement people have had leads to a different beneficial ownership. So there's two layers. And as I say, cohabitation claims, we tend to focus on the equitable, the beneficial interest in the property, because the legal interest is normally fairly straightforward to establish. Okay, so let's have a look at a different scenario. Let's consider that the property owned by Julie and Paul is actually owned legally as joint tenants. Julie paid the deposit, Paul paid for the extension, but they shared all of the costs. They shared the mortgage, got a joint mortgage. Julie had a sole account, she put all the funds went into that, and the mortgage, etc., was paid for that. And when the relationship ends, Paul moves out. So at the point of the relationship ending, Paul decides he's going to move out of the property that's owned jointly between them. He makes no further contributions financially to the mortgage or to the property, maintenance or anything like that thereafter, maintenance of the property. He just decides he's going to leave the property, rent or buy himself a flat somewhere else. Julie remains in the property with the two kids. She pays the mortgage for a number of years, and then in the future she decides to sell the property. So this sort of mirrors a case from a few years ago. You need to be aware that even though the joint ownership was very clear during the relationship, at the point of separation, it could be inferred or imputed that the way in which they both intended to own that property changed because Paul stopped paying for it. So the court could impute or imply from that conduct that actually the common intention at the point of separation was that beyond that point, it was just Julie's property. And they could apportion the beneficial interest in the property differently at the point of sale many years in the future than 50-50. So it's just a flag that at the point of separation, it's really important, if you can agree, and if there is agreement, to record whatever the agreement is in terms of ownership of a property in a separation agreement or something like that, because otherwise you could be faced with a situation where somebody comes back many years later expecting maybe to get an equal share of property they're a joint owner of. Understandable, but they don't get it because it's found that at the point of separation things changed, financial contributions changed. So a steer again, just to record things, think about it, things, life changes, ownership changes, intentions change, record them. Okay, so I just wanted to quickly cover for you claims in relation to children if a cohabiting relationship breaks down. Because many people think that if they're in a relationship which is not a marriage, the financial claims are very limited, and they are, But if there are children of that relationship, then there are claims that can be made in certain circumstances for the benefit of the children, and they can be quite substantial. And they're called Schedule 1 Children Act claims. So everybody has a child maintenance liability. So if you have children, the parent who spends less time with the children will have a child maintenance liability. And we look at the child maintenance service to give you a sort of broad figure there. If you can't agree it, they'll become involved. But you can always look on a website, just Google child maintenance service or calculate my child maintenance. That will give you a guide as to the figures you should be looking at. But beyond that, if there is one party who has very limited financial resources, for example, and another who has very substantial financial resources, then claims can be made for children which include, for example, a property. It could be that the wealthier party is obliged to provide a property for the poorer parent, if I can put it that way, and the child living with that parent, for the duration of that child's minority. So it's almost like on a trust basis. The difference between marriage and separation, where you'll get the property outright or a share of it, is that under Schedule 1 claim, there isn't an entitlement to have a property ad infinitum forever and ever and ever. It goes to you or the other party for a period of time while the children are children. And it reverts to the wealthier party when those children are adults. Obviously, people can come to different agreements. It can be more generous than they need to be, but that's the entitlement. And you can get school fees paid under Schedule 1 claims. You can get a carer's allowance if somebody's had to give up work to look after children, for example. You can get lump sum orders for extraordinary expenses, for example, a car, nursery equipment that costs the children. We all know they cost far more than even the government will sort of calculate on a statutory basis. So it's important to remember that just because you're not married, it doesn't mean that claims can't be made, and sometimes quite substantial claims, for the benefit of any children of that relationship if it were to break down. But it is right that the financial claims are far more limited. That's absolutely right. For example, if you were to separate on marriage and divorce, the pension sharing claims can be made, or pensions can be shared. That isn't the case under Schedule 1 of the Children Act. It's really capital resources, ability to house. It's very focused on a short-term period, really, and it very much depends upon the financial circumstances of both parties. Schedule 1 claims could be a whole nother webinar. That it's just a flag, really. Please don't think that because there isn't a marriage, it means there's no financial claims. There are. You have to look at property claims. You can also look at claims for the children. And in some respects, actually, it can be far more complicated litigation than the litigation or agreements and negotiations that arise out of divorce. All right, so that was a sort of whiz through property law at a fairly basic level, but I hope it sort of explains and flags the areas you need to be thinking about when you buy a property with somebody, or if you've got a property and you're separating, those sorts of things. Now, I thought it might be helpful for Stephanie to take you through a case that we had in the team, which was a property dispute between a couple who had been living together and then separated. So Stephanie, over to you. Talk about this case we had all the way through to a final hearing.
Yeah, so this was a case that Catherine and I were both involved in a few years ago. So the background to the matter was that a 43-year-old gentleman met our client, who was 19 years old at the time. They entered into a relationship and ultimately decided to purchase a property together. However, due to credit issues and financing, our client ultimately ended up purchasing the property with her partner's son. Her partner contributed about £50,000 towards the deposit for the property. Now, at the time of purchase, a declaration of trust was entered into, which protected her partner's £50,000 contribution, and meant that he would receive the first £50,000 of equity or an equivalent share, the property increased in value, and so that's what he would receive at the end of the day. Over and above that, the equity in the property was to be split between the legal owners, so our client and her partner's son. During the relationship and after the relationship broke down, our client contributed to mortgage payments and took out loans to fund works to the property. Upon relationship breakdown, which is about 15 years later, 15 to 20 years later, so a very long-standing relationship, they never married, our client sought to realise her share in that property. However, her partner and his son denied she had any interest in the property whatsoever and alleged that she only facilitated the purchase of the property for them, which they intended to be their family property, and they alleged that any mortgage payments she made were merely rent. So the matter went to court after attempts to negotiate failed. Our client's former partner and his son acted without legal representation, and the case ended up going all the way through to a trial, despite there being the clear declaration of trust setting out the ownership of the property. Now, there was a risk to our client in pursuing this case, as it could have been found that she had in effect never intended to own the property, and that her actions following the declaration of trust had undermined the terms of the declaration. So there were allegations that she was saying, I would never make a claim over the property, it's yours, etc. There was a vague argument put forward by the other parties that she had therefore acted in a way that it would be unfair to disregard, and that they had acted in their detriment in relying on the comments that she had allegedly made. So ultimately it was a dispute of fact, and there were factors of domestic abuse during the relationship that needed to be considered, and everything came out at trial. Ultimately, the judge did not accept the alternative narrative put forward by the other parties, and the written evidence won the day. Without that declaration of trust, and particularly had she not been a legal owner of the property, who knows what would have happened. In the end, the other parties lost the case, and coupled with a refusal to negotiate and their ongoing litigation conduct, our client was ultimately awarded the full extent of her legal costs back, and they received very little of the equity in the property. And that is important to note, that cost orders don't always result in the full extent of costs coming back, but they did here. One other thing to consider is that she could perhaps have been better protected had she also had a cohabitation agreement in place that would have set out the intentions behind that declaration of trust that was in place.
Great, thanks, Stephanie. It was a really difficult, case, that case, and it was difficult for the client particularly because she had to relive experiences during the relationship as part of the evidence at a final hearing. Documents came out sort of last minute that hadn't been seen. Letters that 20-page letters I seem to recall that were written by the former partner to our client, which were mostly very inflammatory and threatening actually, but made no mention of the property, were really relied on by the judge. And of course the declaration of trust that they'd entered into many years ago at the time of purchase, ironically, ostensibly to protect the £50,000 contribution being made by our client's partner at the point of purchase, were really, really important documents. And I think it really underlines the importance of putting things in writing. Because if you end up in a situation where you haven't got something in writing, it is he said, she said, or these days, of course, it's backed up with WhatsApp messages and all sorts of postings on social media. You trail through it all. But if you've got those preliminary documents in place in terms of property and living together, you know, legal ownership, evidence on the deeds, what does it say on the transfer documents, what does it say on a declaration of trust drawn up, you know, because that's going to be very, and in this case was extremely weighty evidence. Is there a cohabitation agreement? So an agreement you enter into at the point you start living together or early on in the relationship when you're living together to say, look, this is the intention. I'm moving into this house. It is intended as per this declaration of trust, or if there isn't one, it is intended that whatever I contribute to this property, for example, I'm not going to benefit from it, all those sorts of things. You can set it out really, really clearly at the outset. And of course, it helps to have those discussions, because sometimes people, you know, can easily move into a cohabiting relationship. There isn't, it's not like a marriage where there's a defined point in time. And actually having those discussions and setting it out in writing can make sure nobody's getting confused or misunderstanding the situation. So it's really, really helpful. So, you know, is it worth a fight? You know, there's a piece of litigation that we're involved with, but we really genuinely don't want clients to have to go to a final hearing, right? I know people think lawyers will want to go to a final hearing. We really don't want to be there. It's incredibly risky litigation, and it's risky outcomes for your client ultimately. So, you know, it's not a good place to be, litigation. So you've got to always try and avoid that battle if at all possible. Cohabitation claims, they are complex. They do require a huge amount of evidence gathering. They're high risk. They tend to be more expensive in some respects than even sorting out divorce and finances because of the level of evidence required. So I guess, you know, the take-home message almost must be, you know, if you're buying a house, if you're having a child, if you're giving up work to care for a child, all these triggers, make sure you get some agreement in writing. It's all about information, isn't it? Making decisions with your eyes wide open, understanding the consequences, and understanding that, you know, there's always risks to litigation. They're expensive to run, and as Stephanie pointed out, you know, very often in cohabitation claims, unlike again divorce and finances, it's the loser who will usually pay the winner's costs. So think about separation agreements at the point of separation. If you can agree something, set it out. It stops an argument for 2, 3, 4 years down the line. If you haven't resolved finances or someone comes knocking at the door for a share of a property, all those sorts of things. Think about cohabitation agreements. You know, these are going to be dealt with as a contract in law, unless there's fraud or duress or undue influence, those sorts of things. You know, these are contractually binding. So litigation definitely should be the last resort. What other options must you think about? Can you think about in terms of resolving family disputes? I'm a partner here at Mills and Reeve, so of course we litigate here, but actually a lot of our cases are negotiated outcomes. You know, you might not hear about them because we resolve them behind closed doors. It's what everybody really should try to achieve if they at all can. And we'll do that by way of negotiations, solicitor-led negotiations. That's got to be the first way of dealing with things if at all possible. But there's other options as well. I'm also a mediator, and mediation is being hugely encouraged by courts now, because courts are under huge pressure. They're underfunded, there's delays, hearings being pulled at the last minute. It's a really difficult place to guide a client through at the moment. And of course, for family disputes, you might suggest, you know, it's definitely the wrong place to be anyway. Whatever's gone on, you're going to be a family, albeit separated. So maybe it's better if you try and resolve your separation in a good way, so that you can remain co-parents if there's children involved particularly. So mediation, where the two of you sit down in a room or virtually with a third party mediator who's not giving you advice, can give you lots of information, but is there to steer the conversation, to guide you towards reaching some sensible proposals in terms of outcomes. It can be really, really helpful. And you can do it on a shuttle basis if you really can't be in the same room together. You know, there's many cases will be suitable for mediation, and even those that some people think might not be, actually are. So it's well worth thinking about. There's a process called collaborative law. So you find a collaboratively trained family lawyer. And the intention there is that you all sign up, lawyers and clients, so 2 lawyers, 2 clients. You sign up, you contractually agree that you are not going to issue court proceedings. And discussions take place by way of 4-way meetings. So you don't have ping pong correspondence. It's 4-way meetings where you sit around a table and you try and sort out an agreement. You hear the advice, so everybody's sharing their views. This can be a really helpful approach. If you've managed to agree lots of things, for example, but there's one outstanding issue, then you can also think about arbitration. You can arbitrate a specific issue. And this can be helpful, again, because it can avoid court delays, and you are guaranteed effectively a hearing because you're booking your judge, but you're paying for your judge as well. But it's a really helpful option for some people. And we've also introduced recently, not just at Mills & Reeve, but other firms as well, so you'll see this around, the 1 lawyer, 1 couple approach. Won't be suitable for everybody, but where a couple who are separating are quite aligned in their outcomes. They might not have, they often don't have an agreement, but they're aligned in their outcomes. They're aligned in terms of what they seek to achieve. Then don't rule out 1 lawyer who can guide them both through that process together. It can be really helpful. So have a think about those things. Evidence everything at every point, at every change in life, if I can put it like that. Circumstances change all the time. Record the evidence. Don't polarize yourselves. Don't push too far apart, because that's going to make it much more difficult to be sensible and collaborative about outcomes, and can push people into litigation, which must always be the last resort. Okay, I apologise if the sound's been a bit echoey. I've seen a message about echoey sound. I'm afraid there's nothing we can do about that right here on today's webinar, but we'll certainly feed that back. And that's a sort of rush through, and I hope it's given you some pause for thought, some pointers, and more than anything, makes you go away realising there is no such thing as a common law spouse. We don't jump over broomsticks any longer. You know, certainly if you do, it doesn't confer any legal rights or obligations on people. So I don't know if anyone would like to ask any questions. There is an opportunity to do so, and you can tap them into the box. I know that one question that came up was in relation to care home fees, and a cohabiting couple where maybe one party needs to move into care. What obligations does the other party have in terms of funding their care? I mean, I can't comment on the system of funding care fees at all. I'm afraid it's not my area of expertise. But what I would say is that with cohabiting couples and claims, the legal ownership, unless there's arguments about property, as I've just outlined, the legal ownership is generally where it rests. So if you bought something and you paid for it and you can evidence it, that is yours unless it's been gifted to the other party. If you have a bank account and it's in your sole name, that is your money, not the other person's money. If you have a joint bank account, but you put all the money into it, arguably that's joint funds. So, you know, if you're looking at resources, you may want to make that clear, and make sure you know where you're putting your funds. And let's have a look at some other questions here.
I've got quite a few questions coming through.
What percentage of cases tend to go to a formal court process? Anecdotally, I don't know the exact figures, and nobody does, of course, but I would say anecdotally probably about a third maybe start court proceedings, perhaps, but the majority of those settle before you get to a final hearing. Because remember, litigation can also encourage people perhaps who haven't been engaging in negotiations to come together and engage, because nobody wants that final hearing at the end of the day. So, you know, we do recognise that we are seeing, you know, as lawyers, we don't see all the cases out there that settle without even lawyers or without, you know, without litigation.
So it will be the minority of people who end up litigating. But just remember, if you are able to resolve matters, please, 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 whether it's a cohabiting relationship that's broken down or indeed a marriage that's broken down, just make sure that the agreement is properly recorded, please, because until it's a final agreement, and that's where you do need legal advice always, it's just not final. So please do make sure you do that.
So we've had quite a few questions about the role of prenuptial agreements. So obviously prenuptial agreements are agreements that you enter into before you get married. Whilst they are not formally binding upon a court in this jurisdiction, they do carry significant influence, providing there are certain safeguards met, there's a level of financial disclosure entered into, parties have at least the opportunity to get independent legal advice, there's no duress, etc. However, as we've mentioned today, there is also the option of a cohabitation agreement, which would apply to cohabiting couples who aren't necessarily intending to get married or may want to get married into the future but aren't right now. And so much of the same considerations that apply to a prenuptial agreement also apply to a cohabitation agreement. None of them are 100% binding in every single circumstance, but typically a cohabitation agreement says what the case is and what the intentions are, whereas a prenuptial agreement might be used to limit claims that would otherwise be available upon the breakdown of a marriage.
Yeah, prenups are very, very important documents nowadays, so it's well worth thinking about getting them if there's pre-existing wealth that you want to ring fence from sharing in the future. You want some control over resolving finances if a marriage weren't to work out. You really do need to think about a prenup agreement. They are very commonplace now. Most of the case law is that they are hugely influential, if not completely accepted by a court on a future breakdown of a marriage. So really, really important documents. Somebody asked here, if two people each own a house alone, which is not unusual, of course, so you have already purchased your property, and then you get together and have children and move into one of those properties, which is therefore owned by one person only, does the other partner have a claim on the house they live in? And the answer to that is it depends on those issues that we've just spoken about. So just by moving into a property, if just someone lives in somebody else's property, they do not automatically get a claim on that property. It doesn't matter whether you've got a child or not, it makes no difference. That doesn't justify the claim. The claim has to be made against the property if, number one, you've contributed a substantial financial amount to it. You might be able to argue result interest. If you've had discussions amongst yourselves where one of you has said, move into my house, this house is going to be owned by us jointly from now on, or something like that. It's never as easy as that, if only it were. So if promises have been made and you can evidence them, then maybe. Or if you actually transfer it into joint names, those sorts of things. Just by virtue of moving into somebody's house, and even if there's a child living there, you don't automatically have a claim against that property at all. So you have a think about that. But again, a cohab agreement might be something to think about there, where you think, well, what are we going to do? I'm going to move into one property. That gives me the benefit maybe of a rental income somewhere. How are we going to deal with that? You know, is that going to be something that I use to contribute towards the outgoings on another property? Those sorts of things. So, you know, two owners, two different properties, you want to have a think about that. Okay, so does the law that apply to property also apply to businesses effectively? For example, GP practices, those sorts of things. Right, so again, cohabiting couples do not have claims against the other party's business at all. By virtue of them being a cohabiting couple and then separating, no. Whereas, of course, if you were married and then you separated, then the non-owning, non-business owner spouse does have a claim against the business, because that could, if it has a value attributable to it, and the businesses are factored into the factored into divorce settlements. I deal with lots of businesses, but if you're living together and one person owns a business, that is their business. Of course, if the other person is a shareholder, it's something different. So it's very much the legal position stands. Okay.
There's one question: would my partner need to be advised by a different law firm? So it depends. If you're entering into a cohabitation agreement, you don't necessarily each have to 100% obtain independent legal advice. Typically, though, the advice is generally you should both have the opportunity to take independent legal advice, and that wouldn't be something that one lawyer could deal with, especially a prenuptial agreement, but equally a cohabitation agreement. You would want to go and get a separate lawyer to look over that.
Yeah, I just want to pick up very quickly on a question which I'll summarise as: if I'm married in England under Islamic law, do I have financial claims in England? And the answer is no, in terms of arising out of the marriage. If you're married in England, you have to have a legally recognised marriage in order to then be able to divorce and have financial claims. If you are married in another jurisdiction, and I think this someone's asked about Slovak law as well. So if you're married in another jurisdiction, in another country, you've got married, and in that country where you got married, it was a legally valid marriage, then that will be recognised here as a legally valid marriage. And if you divorce here, if you have jurisdiction to divorce here, you will be able to make financial claims. So you don't have to have got married in England to divorce in England, but you have to have a legally recognised marriage.
Another question is: how robust is a declaration of trust on its own? So a declaration of trust is strong over property. However, as our cautionary tale has said, there can still be arguments about it. And so it was, as Catherine was saying, it's layers of protection. And the more layers you've got, the better. So a declaration of trust that's supported by a cohabitation agreement that says the same thing is going to be better. But typically, declarations of trust are where these types of disputes start and where they end. However, they're not completely unchallengeable.
Yeah, okay. If I pay for my partner's independent advice for prenup, is this still independent advice? Yes, it is. And actually, it's not uncommon at all to see, for example, the wealthier party when conducting prenup negotiations and reaching prenup. It's not unusual to see the wealthier party say, actually, look, I'll pay for you to go and get legal advice. Just because you pay a lawyer doesn't mean to say they're going to be unable to give independent legal advice. Their duty, remember, is to their client, not the person paying the bill. So their duty is to their client and overall officers of the court. So, you have to behave in certain ways and kept up to fairly high standards. So paying for somebody to have independent legal advice doesn't impact that advice, and actually can be a really good idea because apart from anything else, it says, well, actually, we've got equal information here. No one can say in the future, I wasn't able to afford to take legal advice, I didn't know what I was signing, because you've enabled them to get that advice. So it's generally recognised a very sensible thing to do in the right circumstances. So don't worry about that.
Another question is, can you explain the difference between mediation and the one lawyer approach? So yes, mediators, whilst they can provide information, they can't provide legal advice. Whereas the new model, the one lawyer approach, would be a lawyer who can provide advice to both parties. And so, as we've said, it's typically best and suitable, the one lawyer approach, where parties are generally aligned in their outcomes. Doesn't mean you have to be in complete agreement on everything, but where you need advice as to each party's what would be best for each party. A mediator can't do that. And so sometimes people go to mediation and have lawyers in the background who are advising them.
Yeah, okay. And then the individual circumstances vary, but the key legal rights missing in common law, which could be present in divorce, there is no such thing as a common law spouse. Can I just make that clear again? Sorry if I haven't made it clear throughout this presentation. I think what you're saying is, can we replicate the same rights or financial claims if a cohabiting couple separate as exists for a married couple who separate? Now, you can agree anything you like. So you can't do pension sharing, but you can agree to be more generous than you need to be on a separation. Many people do, because there's a recognition that there's, maybe, a parent, children, sort of want to do the right thing. That's absolutely fine. So you can agree to be more generous than the law requires you to be, and you can set that out in a separation agreement so that you know that there can't be further claims made against you. The law may change. We don't know. The law may change and may impose rights and responsibilities on people who live together, but we're not at that point yet. And one big difference, given the audience we're speaking to, is that you need to remember that if you're married and then divorced, there will be likely sharing of pensions, certainly those accrued during the marriage, and they can be very valuable. If you're living together and you separate, that doesn't happen. Okay.
So we do have a question here. So when is cohabitation really cohabitation? So for example, if a couple live together for 2 years, then they separate for a year and they reunite again, and after they then get married and then they divorce. When does cohabitation start? And the question there is, so as part of getting married, the kind of start date of your relationship is taken to be the date that you began cohabiting. So some people don't realise that you might be living together for 10 years, you get married and then divorced within a year or within a couple of years. The entire length of your cohabiting relationship is taken into account, but it needs to be seamless. It needs to be the seamless cohabitation into marriage. So if there's been a period of separation for a year there, I think you'd definitely have arguments that wasn't seamless.
Yeah, you would definitely. I agree, Stephanie. I agree. And remember, I think what you need to remember is on separation after a marriage, the court have a very discretionary approach. So it's section 25 of the matrimonial clauses that things like how long is the marriage, including seamless premarital cohabitation, rights and responsibilities, resources, earning capacity, mortgage capacity, all those sorts of things. And then they look at sharing and needs and compensation. So, it is a factor that the court would look at if the court were involved, and we always advise as if the court were involved. So, we can give you the range of potential outcomes. I think it would be relevant in terms of the longevity of the relationship, but I don't think it would necessarily mean that the court are going to ignore a year's separation, and of course, when did children come along, all those sorts of things. So everything would be considered.
So another question: after a divorce and dividing of assets amicably without any legal input on either party, can a spouse later make a claim? So what is going to be dependent there? So upon divorce, you can make any decision that you want to in terms of if you can agree together how to deal with your finances. But the important thing there is to get a consent order lodged and sealed with the court. And as part of that consent order, there would be a formal dismissing of financial claims. Without that dismissal, your claims remain open. And we've had it where parties have separated 20, 30 years ago, they never sorted out their finances, or they agreed between themselves but didn't formally record it. Their claims are open.
Or one party agreed at the time, the other party says they didn't agree, and all those sorts of things.
And it opens it back up, and all of a sudden you're 20, 30 years on and you're arguing about what happens then, who said what. Really important to get it dealt with at the time.
The other reason why it is important is because it's much harder 5-10 years post separation to really understand what the marital assets, the assets built up during the marriage were. You're looking back and trying to look back at calculations that are historic very often, particularly because the starting point we adopt to some extent is sharing of assets accrued during the marriage, and less sharing of assets post separation. 1 year post separation maybe, but if we're talking 5-10 years hence, I had a case where they divided everything pretty much sensibly at the time of separation, and then one party went on to build a big business, and then 5-10 years later someone comes knocking at the door. It's really difficult. So do see the benefit. Don't be frightened of going to lawyers to record an agreement. You're adults, you can be given the advice, and you can say, well, yes, it might not be what a court would order, or a court might come here or here or anywhere in between. You can see on the screen doing that, but anyway, two adults can come to an agreement, provided it's within a large range, again, discretionary approach, large range of potential outcomes, the court is likely to approve it as a consent order, and you have protection then against for future claims. Really important. Someone's asked if you haven't had a prenup before you got married, can you do an agreement after marriage? And the answer is yes, it's called a postnup. And these are also very important, particularly common in circumstances where, for example, I don't know, 10, 15 years into a marriage without a prenup, one side of the family wants to gift wealth down, sometimes substantial wealth, and they only gift it if it's going to be ring fenced for the benefit of the bloodline, so to speak. So a postnup it is appropriate in those circumstances. You can ring fence certain assets. Postnup can be appropriate, for example, if someone's going to sell a business and they want to make sure they've got a clear agreement as to who's going to benefit from the proceeds of that at some stage in the future. If the marriage weren't to succeed, you can adopt discussions at a point when you're getting on with one another to enter into a postnup. So you take advice about that, needs to be delicately dealt with. But yeah, postnups, prenups, really important documents, and there will be triggers, various triggers that may guide you towards the need for one, and very often that's wealth falling in.
And just one question, just on the kind of prenups there. Can you make a prenup to stop pension sharing in the event of divorce? So prenups are subject to an overarching view. They need to be fair. Otherwise, to a degree, they're not really worth the paper they're written on, because they're so easily challenged if they're completely and utterly unfair. So as part of it, if the intention was very much, I really don't want to share my pension, I want to keep that ring fence, you'd need quite significant legal advice on that into how could that potentially be seen as a fair outcome.
Yeah. And certainly I've dealt with nuptial agreements where pensions are ring fenced, or premarital pensions are ring fenced. These days people might be getting married in their 40s, 50s, maybe a second marriage, and it may be that the pension accrued before that marriage can be ring fenced, and a clear indication about that. Particularly if both parties have good pensions as well, there's no need to invade those assets.
Is there a cohabiting couple equivalent of a divorcing couple's consent order? So again, yes, a separation agreement. Whilst that doesn't need to be submitted to the court, because there's no claims, you don't have any claims by virtue of being cohabitants. There is no common law spouse. So divorce, you get claims against each other upon getting married. Cohabitees don't have that. But if you want to make really clear what your agreement is, get it in writing in a separation agreement.
Yeah, somebody's asked if the pension was already in payment at the time of marriage. So a pension in payment is a source of income. So if you were to have a pension in payment at the time of marriage and then say separate 10 years later and the pension's still in payment, it's going to be a resource that everybody has to factor in. It may be the only source of income, it may not be, maybe you're still employed as well and you're still generating the income elsewhere. So it will be a resource, it will be an income, so we factor it in that way. But also remember, even pensions in payment, again, it's not when people are living together, just cohabiting, this is marriage followed by separation and divorce. Pensions in payment can be shared as well. Just because they're in payment doesn't mean to say you can't share them, and then sharing would lead to a reduction in the income you're receiving, and the other party then being able to receive that income depending on their age, either immediately or at some stage in the future.
So another question, is it still cohabitation if two people are in a relationship but retain their own separate houses and live together for part of the week due to work commitments? So the principles that apply to cohabiting couples are not limited to cohabiting couples. They're not given to cohabitees by virtue of living together for a certain number of nights. These principles that we've talked about, proprietary estoppel, resulting trust, constructive trust, could apply to people who have actually never lived together in the same home. They're general property principles. So the law doesn't take a view on you have to be together for a certain number of nights. And again, that goes back to the fact that cohabitees are not legally defined in law because you have no benefits by virtue of living together. It's only by virtue of any contributions potentially that you make or intentions or promises that are made.
Yeah. Yeah, pretty much the same for civil partnership as well, in relation to one of the questions asked there. If we've been living together for 10 years, then you retire and then you get married, could you have a prenup to protect the pension at that point? You can have a prenup at any stage. So the prenup comes pre-marriage. If you've been living together, that's not marriage. So before you get married, you can enter into a prenup. Now, remember that if you didn't have that prenup, you got married, and then 5 years later you got divorced, you'd be looking at what we call a 15-year marriage. 5 years marriage, 10 years pre-marriage, seamlessly into marriage, 15-year marriage. And of course, pensions can be shared, and arguably 15 years worth of pensions. It depends on other factors as well, of course. But again, you could enter into a prenup if there was a particular way of dealing with pensions that you were both agreeing to, and if that broadly did come out with a fair, can be mean, of course, but broadly within the range of outcomes, and you have an idea of each other's finances, etc., has been disclosure. So yeah, you can deal with that as well.
But there is still a risk, and that's the thing with prenups, that prenups are not, as I've said before, they're not binding, and so the only way to 100% prevent your pension from being shared in that situation is to not get married. Yeah. That is the best protection that you have, because when you get married, the court has such a sweeping discretion. Even if there is a prenuptial agreement, if there's been a change in circumstances that mean that prenuptial agreement isn't fair anymore, it won't be followed.
Yeah, just very quickly, I'm not going to address it in detail because it can be quite complex. But if you have the ability to get divorced in this jurisdiction, and you also have an ability to get divorced in another jurisdiction, then very often the jurisdiction in which you divorce will then be the jurisdiction which deals with finances. And you will need to be taking advice in both jurisdictions to decide whether one jurisdiction is going to be more favourable, give you a more favourable outcome than the other. Even then, if you have been divorced in a foreign jurisdiction, not England and Wales, and you've had a financial outcome, depending on the circumstances, and it's rare circumstances, maybe in certain cases, there are applications that can be made here for financial divorce, financial relief after foreign divorce. So these are all very fairly specialised areas. I think probably we're going to wrap it up now. 1 minute to 2. We really haven't been able to get through all of those questions. There's loads of them. I'm really sorry, but I hope that's been helpful to you all. It's been brilliant actually answering those questions. Really good fun. But you know where we are. If you have queries, you can contact us. That's not a problem at all. And I hope that you've picked up some pointers, even if it's just pointers to get things in writing, to think about the benefit of legally binding written documentation, which can feel painful at the time, instructing a lawyer to do that or addressing those issues. But honestly, if it saves the heartache 5-10 years in the future, makes things a little bit easier then and saves you costs then, it's well worth doing. So we'll leave it like that for now. Thank you very much, and I hope you all go off and have a good afternoon. Okay, thanks.
Thank you very much.